SwayamPrabha. Digital India. Educated India.
Well, students, my name is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. So, this is my new course, and the topic of today's presentation is historical background of human rights. I have chosen this topic, and the course name is Human Rights and Criminal Justice System. So, in this course, the first topic the first lecture which I have chosen, that is historical background of human rights. So, in this lecture I would like to highlight evolution of human rights, history of human rights, what are the important international documents through which human rights emerged, or we can see human rights in different forms. So, in this lecture I would also like to highlight a few important international document and national documents through which human rights have been guaranteed to the citizen of India as well as people of across the globe. So, let us start. You see, this is my first lecture, historical background of human rights. So, in this lecture I would like to give precise definition of human right and then characteristics of human rights. So, you see, many times students have confusion about human rights and fundamental rights and legal rights. So, I would like to make difference between human rights and fundamental rights as well as statutory rights or legal rights. So, first of all I would like to define human rights. So, you see, human rights are those basic rights which are given to the human being just because of human. So, a person who can claim his all basic rights as a human being, not because of citizen of any country, that right must be given to a person because of human being. So, human rights are those fundamental rights, those basic rights which are given to the people just because of human being. For example, right to equality, right to life. So, though this word has not been specifically defined, but I would like to give a definition of section 2 definition of human right provided in the Protection of Human Rights Act 1993. But what all those rights which human being are entitled to avail as a human being can simply be considered as human rights. For example, right to equality. So, you see, every person is equal in eye of law, and being equal, every person has right to live with human dignity. These rights or human rights are as old as hills and mountains. It is said that human rights are as old as hills and mountain. So, this right, there are two important ideology, there are two important school which talks about human right. So, with the help of these two school, these two different approaches about human rights, we will try to understand meaning of human rights and significance of human right. So, you see, one school is as you all might be knowing that natural school of jurisprudence, and second school is analytical school of jurisprudence, positivist school of jurisprudence. So, natural school of jurisprudence or exponent or scholar of natural school of jurisprudence, they argue that human rights or parent of law. Human rights are above the law. So, even law derives its authority from human rights. So, they are of the opinion that human rights are above the law. So, let us understand this perspective. Human rights are parent of law. When we use this word parent of law, it means law derives its authority from human rights. Human rights are above the law. Why? A scholar of Natural School of Jurisprudence, they make this kind of remark about human right, because they consider human right as more precious or pious rights, and they consider human rights above the law. As you all might be knowing that law is enacted by the legislature, law is made by the legislature, and legislature is important part of the state. So, legislature being important component of state has to make the law. So, Natural School of Jurisprudence and a scholar of Natural School of Jurisprudence, they argue that state cannot recognize or cannot guarantee human rights. Human rights are as old as hills and mountains, and even state is bound to respect the human right. State cannot take away the human right. So, you see they say that human rights are above the law, and while making the law, legislature should keep in its mind that human rights should not be curtailed or should not be taken away by the legislature. So, they had, you see, they had apprehension that if human rights would be recognized and guaranteed by the state, by the legislature, that can easily be taken away, that can easily be violated, that can easily be abrogated by the state. So, because of that apprehension, a scholar of Natural School of Jurisprudence, they put human right above the law. So, human rights are above the law. This is one approach about human right. Second important approach is positivist school, analytical school. Analytical school of jurisprudence, that ideology is in favor of that even human rights are guaranteed by the law. Law is enacted by the state, law is enacted by the legislature, and when we use this word, human rights are recognized and guaranteed by the state, meaning thereby human rights can also be recognized and protected by the state. So, a scholar like Austin, Salmon, Bentham, these names have played important role in analytical school of jurisprudence. They are a scholar of positivist school like Austin, Salmon and Bentham. So, they argue that all the rights are creation of the state, all the rights are recognized and protected by the legislature. So, human rights are not above. So, they argue that even human rights are recognized by the state. When they use this word all the rights, it means fundamental rights, legal rights, human rights, all the rights are recognized and protected by the state, meaning thereby human rights are, they argue that human rights are not above the law. So, they argue that human rights are the child of law. Rights are the child of law. It means when you use this word, rights are the child of law, it means child is a creation of parents. So, similarly, rights are the creation of the state, rights are the creation of the legislature. So, they argue that not a single right can be considered as legal right or statutory right unless that right is protected and guaranteed by the legislature. So, they say that legal right, statutory right are recognized and protected by the state. It means if any interest, and the meaning of right, you see, right is an interest vested in a person. So, right is an interest vested in a, so that interest, right is an interest recognized and protected by the law, and law is, as you all might be knowing, that law is enacted by the state. So, once right is recognized and protected by the state, it means that right can also be abrogated or taken away by the state. So, in the light of the what I am trying to, you see the point which I am trying to justify, that there are two different approaches, there are two different views about human rights. One view strongly advocates, favors that human rights are above the law, and a scholar of that natural school of jurisprudence, they argue that human rights cannot be taken away by the state, because they had apprehension that human rights, if human rights would be recognized by the state, state machinery can take away the human rights. So, because of that apprehension, they did not accept state intervention in the recognition of human rights. So, that is why they consider that human rights are above the law. On the other hand, second view is that human rights or creation of law, even human rights can also be created by the state. So, human rights are the child of law. So, in the light of these two different ideology, in the light of these two different views, we will try to understand the meaning of human rights. So, this is one aspect of human right. With the help of these two different views, you must understand the meaning of human rights. One view, one ideology makes emphasis on state intervention, state recognized right, and on the other hand, one view, one ideology, one school of law emphasize on natural right. Human rights are considered as natural right, they are creation of the nature. So, in the light of these two different views, you should try to understand the meaning of human rights. Second important view, you see, the scholar of natural school, they argue that human rights are not guaranteed by the state. State is not guarantor of the human right. State is only protector of the human right. State here means legislature, executive, and so state here means is only obliged to protect human right. State is not guarantor of human right. State is only protector of human rights. So, as I said, human rights are as old as hills and mountains. So, a scholar of natural school, they argue that human rights are not guaranteed by the state. State is only protector of, it is the duty of state to protect human right, and state cannot guarantee the human rights. On the other hand, a scholar like Austin, Salmond and Bentham, Jeremy Bentham, they argue that state is guarantor as well as protector of human rights. So, you need to understand these two things. Austin, Salmond and Jeremy Bentham, they argue that human rights are guaranteed and recognized by the state. So, state is guarantor of the human right as well as protector of the human right. So, you see how this second ideology, this second view is very much nearer, is very much close to the definition given in the Protection of Human Right Act 1993. Section 2D of the Human Right Protection of Human Right Act 1993 makes it clear that human rights are those rights which are guaranteed. You see, I am referring section 2D of the Protection of Human Right Act 1993, which Indian Parliament enacted in the year of 1993 just to recognize human rights as a basic right for Indian citizens, and two important commissions, National Human Rights Commission and State Human Rights Commission, for the protection of human rights of Indian citizen. Indian Parliament enacted the Protection of Human Rights Act 1993, and in that very act section 2 defines human right, and now I am referring section 2D. According to section 2D of the Protection of Human Rights Act 1993, human rights or the rights relating to life, liberty, freedom and dignity of individual, which are guaranteed by the Constitution or embodied in international covenant and enforceable by court of law within territory of India. So, I have just referred meaning of human rights given in section 2D of the Protection of Human Rights Act 1993. So, according to section 2D, human rights are rights relating to life, liberty and dignity, which are recognized by the Constitution or embodied in international covenant and enforceable by court of law. So, this definition is very close to analytical school of jurisprudence. This definition is very much connected with second view of second ideology of school of analytical school of jurisprudence, Jeremy Bentham, Austin, because they also argue that human rights are recognized by the state. State is the guarantor and protector of the human right. So, this definition is very close to this ideology, because if human rights are recognized by the Constitution and that human rights are enforceable by the court of law, it means that those rights which are not enforceable by law, by the court of law, that right cannot be considered as human right according to this definition. And those rights which are not recognized by the Constitution, those rights cannot be considered as human right, or rights which are not embodied, mentioned in international document, international covenant, that right cannot be considered as human right. So, as you all might be knowing that we are all having two important international covenant on civil and political right 1966, and second important covenant, international covenant on education, culture and social 1996. So, ICCPR we are also having two important international covenant. So, in these two important covenant, right to life, right to equality, right to food, I will discuss all these things in detail. So, you see what I wanted to justify? I wanted to justify that human rights are guaranteed and protected by the state, and different international covenant, multilateral agreement will make it clear that human rights are recognized and protected by the state. So, you see with this Austin or Jeremy Bentham are more relevant, in my opinion, they are more relevant in Indian context, because so now come to this characteristics of human right. With the help of this screen, with the help of this slide, I would like to highlight few important feature of human rights. You look at this. The first is universal. Human rights are universal. It means irrespective of reason, human rights are birthright, and every person is entitled to get all those basic rights which he can get or she can get as a human being. So, every person is entitled to be treated equally. Every person is equal in eye of law across the globe. So, this is the most significant feature of human right, that a person is equal on this universe, on this globe. So, universality is first important significant of human most important feature of human right. So, for example, an Indian citizen cannot lose his human right when he goes to America or England, or a British citizen or US citizen cannot lose his or her right, human right, once he left his country. So, universality, human rights are universal in nature. The second important feature of this human right is human right, you just look on your screen, you see second important feature is inherent character. Human rights are inherent, birthright. So, every person, as I said, every person is equal by birth. Third important feature of human right is inseparability. Human rights are inseparable, it cannot be separated, means human rights are inseparable, it cannot be separated with the person. Fourth important feature of human right is inalienable. It means this right cannot be transferred, this right cannot be taken away by the state. This right, human right, cannot be alienated, cannot be transferred by one person to another person. So, this is very much inherent in human being, and even state cannot take away human rights. So, these are four important feature of human rights. Now, come to historical background of human right. As we all know that Magna Carta, I have mentioned some important international instrument, so that I can explain this human right in a very precise manner. You see, the first important documentary evidence about human right is Magna Carta 1215. So, Magna Carta Charter, Magna Carta 1215, that is the first documentary evidence pertaining to human right. So, you see, you all might be knowing that in 1215 AD, the British citizens, they started revolt against the King John. King John was the ruler of that, was the ruler of England, and people of that country, they started revolt against their king, and they demanded that their rights should be given to the people, and king had no power to impose unreasonable taxes, unreasonable restrictions. Even king had no power to impose taxes on upon the citizen of that country. So, as a result of that, King John recognized some rights to the subject, so that revolt, so that dispute could be minimized. As a result of that, Magna Carta 1215 is considered as first important document. The second important document is in English Bill of Right 1689. So, that English Bill of Right 1689, British Parliament enacted this piece of legislation in 1689 just to give liberty to the subject, just to give liberty to the citizen of that country, Britishers, British. So, British Parliament in 1689 tried to recognize certain human rights to the people of England, British citizens, and British Parliament, as you all might be knowing that British parliamentary supremacy of Britain, that British Parliament can make any kind of law except male to female or female to male. So, it is said about British Parliament that British Parliament is so supreme that British Parliament can make any kind of law except male into female or female into male. So, British Parliament tried to give some liberty to the people of that country, and supremacy of king or crown was reduced in this 1689, and it is said that in 1689 it was established that British Parliament is supreme and king was not supreme. King should not be treated as, even king should be subject to the law and not law should be subject to the king. So, this is second important document, Bill of English Bill of Right 1689. The third important bill is US Bill of Right 1791. You just look at on your screen the US Bill of Right 1791. As you all might be knowing that even USA was a colony of England, and United States of America was the first country which started revolt against England. So, the people of 22 states of United States of America, they started revolt against England and they got freedom, they got independence, and they tried to make their own constitution, and by that constitution the US Bill of Right 1791 is considered as important document through which US citizens they got their rights from that document. So, this is third important international document pertaining to human right, and fourth is French Declaration of Rights. As you all might be knowing that after French Revolution, the citizen of that country got certain liberties, and ultimately United Nations General Assembly in 1948, as I have already highlighted as UDHR 1948. So, United Nations General Assembly in 1948 made a declaration, that name of that declaration is Universal Declaration of Human Rights 1948. So, you all might be knowing that on 10th December 1948, United Nations General Assembly with the help of its members passed a resolution for what? Just to give liberty to, just to recognize certain freedoms of the citizen across the globe, member states, and India is also important member of United Nations, as you all might be knowing that UNO emerged as an important international body in 1945, and after the emergence of UNO, United Nations General Assembly in 1948, 10th December 1948 resolved a declaration, the name of that declaration in Universal Declaration of Human Rights 1948, and by this declaration certain human rights have been guaranteed to the people of this universe. So, Article 1 is very important. So, you now next UDHR 1948, I have briefly it is referred as UDHR 1948. So, you see the first important provision of Universal Declaration of Human Rights, this is one important international instrument regarding human right, and the first provision of UDHR is right to equality. So, you see I with the help of this slide I would like to make it clear that right to equality is the first human right provided by this international document. Every person is equal by birth. It is specifically mentioned in Article 1 of UDHR that every person is equal by birth. So, Article 1 is very clear, Article 1 of UDHR. The third important provision is right to life. According to Article 3 of UDHR, every person on this universe has right to live with human dignity. So, in order to ensure human dignity UDHR, United Nations General Assembly, recognized this right to life as human right. So, every person on this universe has right to live with all human dignity. So, this is second important right provided in UDHR. The third one is protection against arbitrary arrest. Protection against arbitrary arrest, no person shall be subjected to torture or no person shall be arrested in arbitrary manner. So, this kind of protection is also a human right provided by this Article 9, provided by this UDHR. Next important human right is protection against inhuman treatment and torture, Article 5. So, Article 5 of this UDHR gives a protection to every person on this universe. Inhuman treatment or not to be treated, or every person on this universe has right to get fair treatment. So, inhuman treatment would be violation of human right. It is mentioned in Article 5 of UDHR, and the fourth is next is right to fair trial. Article 10 of this UDHR talks about right to fair trial. Every person is entitled to be tried fairly by any competent authority. So, right to be tried fairly, it is an important human right mentioned in Article 10 of this UDHR. So, you see, I have covered all these human rights in which have been provided by this UDHR, right to fair trial, protection, and you need to understand that since the course proposal is human rights and criminal justice system. So, I have chosen those human rights which are directly connected with criminal justice system. I have not covered all kinds of human rights, just you can see on your screen that I have chosen right to equality, right to life, Article 3, but Article 2 is missing in this, Article 7 is missing, Article 8 is missing, Article 9 I have referred Article 9, I have referred Article 5, but Article 4 is missing. Why? Deliberately I have not chosen that article, that provision, because that is not concerned with criminal justice system, that is not concerned with my course proposal. So, that is why I have chosen those relevant human rights which are directly connected with criminal justice system. So, if right to life is violated by any government agency, then criminal justice system will come into picture. If a person is not tried fairly, then criminal justice system will come into picture. If someone is arrested by the police officer unlawfully, then criminal justice system will come into picture. So, that is why I have chosen those relevant human rights which are directly connected with criminal justice system. For example, right to education is also human right, and right to marry, right to property, these are also human rights, but these rights are not directly connected with my paper. So, that is why I have not chosen those areas, those human rights which are not directly connected with this course. So, you need to understand this thing. Now, right to fair trial and protection against inhuman treatment, right protection against torture, physical violence. So, these human rights are directly connected with this course proposal. So, I have chosen these human rights, and if physical violence is committed by police atrocities are committed, then in that situation criminal justice system will come into picture, judiciary will come forward to rescue, to provide effective safeguard, effective measures to the deprived person. So, that is why I have chosen these human rights from UDHR. Now, come to this slide, UDHR 1948 second part, So, right to be presumed innocent, this is also a human right provided in article 11. Every person is presumed to be innocent unless his guilt is proved by the court of law. This, you see, this is also specifically provided in article 11 of this UDHR, that every person is innocent unless his guilt is proved before the court of law. So, court is bound, judiciary is bound to presume that person who has produced before the court is innocent, unless contrary is proved, unless it is established before the court by the prosecution that accused has committed that crime. So, court is bound to presume that person is innocent. This kind of liberty is provided under article 11. Now, come to article 11, also. Article 11 talks about two kinds of human rights. One is right to be presumed innocent and no punishment without law. No one can be punished without law. If someone has not breached the law, he or she cannot be punished. It would be violation of human right. So, unless law makes unless law provides penalty for any particular act, no one can be punished without law. It means a person cannot be prosecuted and convicted for that act which is not an offence on the date of commission of the act. So, this is the meaning of no punishment without the law. No one should be punished for that act which is not crime on the date of commission of the act. Now, third important right is right to privacy. Every person has right to enjoy his life or her life according to his choice, according to her choice. So, right to privacy is also a human right. No one can intervene, even state is not allowed to intervene. No one can intervene in privacy of another person. It would be violation of fundamental right. And you see, these human rights are recognized as a fundamental right in our constitution, in the Constitution of India, part 3rd of the Indian Constitution. I will also discuss that part of the Indian Constitution. Right to marry, article 16, every person has choice to marry with any other person to whom he or she likes. So, right to marry, that is also a human right. Right to property, article 17, I have already highlighted right to property. You all might be knowing that right to property, considering the gravity of this right, our constitution makers, they were very much aware about these things which happened in 1948 at San Francisco in USA. So, our constitution makers, when they were drafting our Indian constitution, they were very much aware about all these things which happened in 1948. So, deliberately our constitution maker, they put right to property, they considered right to property as a fundamental right, and because of that reason right to property was put in part 3rd of the Indian Constitution, and right to property was considered as fundamental right. But in 1978, when Janata Party government came in power, so in 1978 right to property was amended and it was taken away from that part of the fundamental right, and in 1978 Indian Parliament reduced the status of right to property from fundamental right to constitutional right. So, right now the actual position of right to property is it is not a fundamental right in India, it is only statutory right. So, you all might be knowing this. So, I just want to connect this human right with our constitution, with the Constitution of India. Now, come to this UDHR, right to freedom of religion, article 18, right to freedom of opinion. I have just highlighted UDHR 1948 part 3rd, you see right to freedom of assembly, right to work and equal pay for equal work. Article 23 talks about right to equal pay for equal work, that is also human right. Everyone has right to education, right to education is human right, though you all might be knowing this, right to education is human right, and this right to education was accepted as human right in 1948, and Indian Supreme Court in the year of 2002 recognized right to education as a fundamental right in case of PUCL versus Union of India. So, you see how though we are too late in recognizing right to education as a fundamental right, we took more than 30 years to recognize right to education as a fundamental right, and right to education was human right in 1948, and in the year of 2002 Supreme Court for the first time recognized right to education as a fundamental right, and Parliament took 7 years in making law on that point. Right to Education Act 2009 was enacted by the Parliament in 2009. So, Right to Education Act 2009, now you can see the ground reality of right to education, though this right was considered as human right in 1948, and this right was recognized as a fundamental right in 2002 by our Supreme Court, and Parliament enacted a special legislation on right to education in year of 2009. So, you can see the ground reality of right to education in our Indian legal system. Now, come to I have just make a difference between human rights and fundamental rights with this slide. One side I have referred human rights UDHR, and another side I have tried to refer those relevant constitutional provisions which are directly connected with human rights provided in UDHR. So, UDHR human rights and fundamental rights which we have recognized in part 3rd of Indian Constitution. You can just see this comparative chart. Right to equality, Article 1. Article 1 of Universal Declaration of Human Rights talks about right to equality. In our constitution, in our legal system, we have recognized right to equality as a fundamental right in part 3rd under Article 14 of the Indian Constitution. You just can see Article 14, Article 1 and 14. Right to life, Article 3 and Article 21. Article 3 of UDHR talks about right to life. Our Indian Constitution has recognized right to life as a fundamental right under Article 21, as you all might be knowing this provision. Protection against inhuman treatment. This kind of human right is provided in Article 5, and protection against inhuman treatment, that is derivative rights, and this right was recognized by Indian Supreme Court in 1980 in Sunil Batra case. Sunil Batra versus Delhi Administration, AIR 1980 Supreme Court. In Sunil Batra case, Supreme Court for the first time held that protection against inhuman treatment is very much enshrined under Article 21 of the Indian Constitution. If authority has failed to protect this right, it would be violation of fundamental right guaranteed by Article 21 of the Indian Constitution. So, by that judicial pronouncement, we have got protection against inhuman treatment as a fundamental right under Article 21. Right to fair trial, Article 10 talks about, Article 10 of this UDHR talks about right to fair trial as a human right, and this right to fair trial is essential component of Article 21 of the Indian Constitution. And right to fair trial, this is right to property, right to life and personal liberty, this is essential component of. So, you see right to fair trial, how right to fair trial is connected with Article 21, you can just see on this. On your screen you see right to fair trial, article 10 of UDHR, and this is connected with article 21 of the Indian Constitution. So, right to property, article 17 UDHR, I have just, you see UDHR one side I have written this UDHR and Indian Constitution. Right to property is human right, and right to property in our Indian legal system, that is constitutional right, article 300. Earlier it was a fundamental right, but as I said, in 1978 Parliament reduced its constitutional status from fundamental right to property, article 300. Right to freedom of religion, every person has right to profess his religion of his own choice. So, right to freedom of religion, article 18 and article 25 in our legal system, article 25 of the Indian Constitution talks about right to freedom of. Now, come to this slide. I have also categorized human rights in different categories, types of human rights. You see, as you all might be knowing that there are two important international covenants. When I use this word covenant you just understand that covenant is bilateral or multilateral agreement between the parties or among the parties. So, here International Convention on Civil and Political Rights or International Covenant or Convention on Economic, Social and Cultural Right 1966. In brief, it is referred as ICCPR, International Covenant on Civil and Political Right 1966. So, these are two important international documents wherein human rights are specifically enumerated. Those human rights which have got place in these two important documents, I would like to refer one by one. Right to life as a human right, protection against inhuman treatment, right to fair trial, freedom of forced labor and right to equality. So, these are human rights specifically mentioned in this international instrument, international document ICCPR. And second important international document is, which I have also highlighted, International Covenant on Economic, Social and Cultural Rights 1966, right to work. So, by that international document, obligation was imposed upon member state to make such kind of law in their countries to provide employment, to provide education to their citizen, to provide work employment to their citizen, in order to provide food, nutrition, in order to provide good health. Every member state which has signed this document is bound to make law on these points. So, right to food, as already highlighted, right to food, that is also fundamental right under article 21, and this right to food was considered as human right in 1966. Though we are too late. How we are too late? We are too late in recognizing right to food as a fundamental right in our legal system. This right to food was also recognized as a fundamental right, as a part of article 21 of the Indian Constitution by the Supreme Court in the year of 2002. And you just can see this international document which was signed by India in 1966. India is party of this multilateral agreement that we have made, we have put signature on that document. So, being signatory member of that international document, we will try to provide food free of cost to those people who are unable to manage their livelihood. Right to food was recognized as a fundamental right in 2002. in PUCL case. I have highlighted this case in my previous lecture. Right to food as essential component of right to life of Article 21, PUCL versus Union of India, AIR 2002 Supreme Court. And Food Security Act was enacted by the Parliament in order to provide right to food as a fundamental right to poor people, to deprived people, right to health, right to education, right to equal pay for equal work, right to social security. You see, these rights are considered as human right, and we have also, it means Indian Supreme Court has also recognized these rights under Article 21 of the Indian Constitution. Those human rights which have been recognized in ICCPR or International Covenant on Economic, Social and Cultural Right have not been covered by Part 3 of the Indian Constitution directly. Indian Supreme Court has recognized those important human rights which did not get place in Part 3. Considering the gravity of those human rights, Indian Supreme Court has recognized those human rights as a part, as integral component of right to life, Article 21 of the Indian Constitution. You will be happy to know that right to food, right to health, right to education, these human rights have got a recognition under Article 21 of the Indian Constitution only because of Indian Supreme Court. So, you need to understand this thing. Now, come to this the Protection of Human Rights Act 1993. I have already highlighted those important provisions provided in this Act. Indian Parliament, you see, Indian Parliament in 1993, considering the gravity of human right, enacted a special legislation for protection of human right, and the name of that special legislation is the Protection of Human Rights Act 1993. Important thing which you need to remember, that is section 2D. Section 2D of this Act, section 2D talks about human rights. According to section 2D of this Act, as I have already highlighted, but just I want to repeat it. According to section 2D of this Act, human rights are those rights relating to life, equality, liberty and dignity of individual. 4 rights, it means Article 2D talks about 4 types of rights. Human rights are rights relating to life, equality, freedom and dignity of individual. So, dignity of individual is very important and liberty of individual is very important. Life is very important, life of individual is very important. So, life, equality, liberty and dignity of individual, which are guaranteed by the Constitution of India itself guarantees all these rights, which are guaranteed by the Constitution or embodied in international covenant. So, these rights are already embodied, provided in international covenant. International covenant here means ICCPR, International Covenant on Civil and Political Rights 1966. So, these rights are specifically provided in that international document, which are enforceable by court of law, means these rights are enforceable by the court of law. Supreme Court and High Courts under Article 32, I just want to mention this 32 and 226, Article 226. These human rights are enforceable by Supreme Court under Article 32. These human rights can also be enforced, implemented by High Courts under Article 226 of the Indian Constitution. So, this definition is very much close to this school, analytical school of jurisprudence. As I said, you see this school, analytical ideology, talks about human rights are child of law, state is guarantor of human right as well as protector of human right. So, with the help of these two definitions, state is guarantor. Natural school of jurisprudence, they have put human rights above the law. So, they argue that human rights are parent of law. This is the first view expressed by natural school. Human rights are parent of law, and second is state is not guarantor of human right, only protector of human right. So, in the light of these two, you will have to understand this the meaning of section 2D of this Human Rights Act. So, with the help of these slides, I try to highlight few important international instruments, so that you can get entire information relating to human rights, you can get entire information pertaining to human rights and agencies, authorities through which human rights can be enforced, and what are those human rights which are directly connected with criminal justice system, and those rights which have been covered in the part 3rd of the Indian Constitution. So, I do believe that you all must have understood the things which I have discussed in this lecture, and right from Magna Carta 1215, English Bill of Rights 1689, US Bill of Rights, and French Revolution French Bill of Rights, and UDHR 1948. Then I have also covered two important international instruments, and so that you can get entire perspective of human rights. And one most important thing is that many times it is asked from the student that what is the basic difference between declaration and covenant, whether UDHR is more important or ICCPR is important. Universal Declaration, which was enacted, which was resolved by United Nations General Assembly in 1948, that UDHR is important, more important than International Covenant on Civil and Political Right, or ICCPR, this international covenant is more important than UDHR. So, you need to remember that UDHR 1948 is mere declaration, that is normative approach, that is idealistics set by prescribed by United Nations General Assembly in 1948. But ICCPR, this is multilateral agreement. So, these two important international instruments, International Covenant on Civil and Political Right and International Covenant on Social and Cultural Rights, these are multilateral agreements. So, breach these multilateral agreements, covenants are binding on the states, countries which have signed this international document. So, international covenants are more important than declarations. This is if significance is ours. So, because this is a kind of agreement, multilateral agreement. So, this is more important. So, I think I have covered each and every aspect of human right, and with the help of section 2D of the Protection of Human Rights Act 1993, I tried to give precise definition of human right provided in this act, and section 2D of this act makes it clear that human rights are those rights relating to life, liberty, dignity of individual, and embodied in international covenant and enforceable by court of law. So, I think though this section 2D argument is made that section 2D is not complete, I do not want to go into the technicality, but with the help of this section 2D you need to remember all these things, and whatever human rights have been provided, recognized by these two important international instruments, we will try to understand that how these human rights are directly connected with part 3rd of the Indian Constitution, with our legal system. And with this I would like to conclude my lecture, assuming that you all must have understood what I have discussed in this lecture. Thank you all.